We'll start at the right time. That's why I logged in at the right time.
Sir.
Nirmala madam?
Yes, madam.
Shall we begin?
Yes.
It's already 5 o'clock.
Yes, madam.
We'll start the session. Okay.
Good evening, esteemed chief guest, respected principals, and distinguished faculty members from various institutions. It's my pleasure to extend a warm welcome to day 3 of 7-day faculty development program on criminal laws. We are honored to have with us today our speaker, Professor Dr. C.S. Patil sir, Director of KILPA, Bengaluru. Today's session will delve into the changing paradigm of criminal jurisprudence, a topic of great relevance in the current legal landscape. Due to some unavoidable circumstances, our principal is unable to join us today. On behalf of Janta Education Society's Vivekananda College of Law, I have honor of welcoming our distinguished speaker for today's session. Professor Dr. Chidananda Reddy S. Patil graduated from University of Mysore in 1983. He moved over to Dharwad to pursue his studies in law at the University College of Law. He completed his LLB in 1986. He obtained master's degree in law from University of Mysore in 1988, specializing in constitutional law. He secured first class and first rank at LLM, for which he was awarded 2 gold medals and a cash award by the University of Mysore. In addition, the government of Karnataka has awarded him cash prize for securing first rank in LLM. He holds a doctorate in law from the Karnataka University, Dharwad. Professor Patil has taught law for over 3 decades at JSS Law College, Mysore, HA Law College, Dharwad, KLE's Law College, Bengaluru, University College of Law, Dharwad, and KSLU's Law School, Hubballi. He was a professor at Karnataka State Law University, Hubballi, Karnataka, and has discharged responsibilities as Dean Member of the Syndicate and Academic Council of KSLU and Director of KSLU's Law School for 7 years and Head of the Research Center for Democracy and Constitutional Government. So he superannuated on 31st August 2023. Presently, he is working as Director, Karnataka State for Law and Parliamentary Reform, Bengaluru. Professor C.S. Patil sir has written 1 book, edited 4 books, and more than 85 articles in law journals. He is one of the experts to submit a research paper to the Committee on Reforms of Criminal Justice System, of which Honorable Dr. Justice V.S. Mallimat was the chairman. He has drafted many legislations for the government of Karnataka, including the Karnataka State Human Rights Codes Rules 2006. He has received a commendation for his work in the field of human rights in 2010. He was a member of the Expert Committee for Establishment of Karnataka Rural Development and Panchayat Raj University, Gadag. It's now my great pleasure to invite Dr. Professor C.S. Patil sir to commence today's session. We are eager to hear your insights and expertise, sir. Over to you, sir.
Thank you.
Thank you, sir.
Thank you very much. It is so nice to be here. Professor Dr. Kempegowda, the principal of the Vivekananda College of Law, telephoned me and expressed his inability to join on the platform, and he said by the end of the session he may be joining also, and that is always a pleasure to have friends on the platform. One of my students has sent back one of the statements which I sent him earlier in the form of a message. When you perform publicly, you are opening up yourself for criticism. Okay. And instead of taking criticism from someone else, it is always nice to be criticized by our own friends so that we can mutually improve and go out as polished products when we exhibit our ability and talent somewhere else. I really miss the presence of Professor Kempegowda, Dr. Bhuvaneshwari, Dr. Nirmala, Dr. Jagdish, Dr. Vishwas. I am seeing quite a few. Madam Veena is there. Quite a few familiar faces and names here. And it is so nice to address all of you, around 57 of you who are here on the platform, and share some of my information as to what are the paradigm shifts that are taking place in the field of criminal law during our course of time. Usually, when we discuss, we say, when I was in college, this was the amendment. When I was in service, this was the amendment. So, being a part of my generation and being a part of your generation, we are witnesses to the overhauling of certain of the laws. We are witnesses to enactment of new laws, and we are fortunate enough to have all those great judgments of the Supreme Court, which come onto our laptops, our telephones the very next day. And really, it is a sort of information explosion, change in the regime that we are undertaking and we are witnessing. And it is always so nice to be part of the program, to share the information that I have about you people. Okay, so with that we start. What are the changing paradigms of criminal jurisprudence? In this context, we have to go back. We have to go back to the early days during the laissez-faire era, wherein the laws were different. And in the aftermath of the Second World War, all the democratic countries world over have adopted controlling constitutions, a sort of hegemonic normative constitution which will control the exercise of power at the hands of power holders. So when we adopt a constitution, I keep on repeating, please, as law teachers, read the wonderful book of Lawrence Strait, Reading the Constitution. So he says, making the Constitution is a bold experiment on the part of the population to create a document to which all of them will subject themselves, and the document which will control all the creatures of the Constitution. In other words, the Constitution will structure the exercise of power. And for that purpose, we always think in terms of channelizing the power, regulating the power, or to put it in other words, power should flow only through permitted channels as permitted by law. That's what we call rule of law. Rule of law. Okay. So when countries adopted these new constitutions in the aftermath of Second World War, all of them invariably have included a charter of liberty in their constitutions. If you refer the Delhi Declaration on Rule of Law by International Commission of Jurists, and if you go through some wonderful books on administrative law by Craig, Garner, and Wade, you will make out that the quest on the part of the individual is to control power. Just natural of Romans, divine law of medievalists, rule of law in the modern era. We tried with separation of powers. We tried with division of powers. And we are experimenting with the rule of law. See, what is that rule of law? What is that charter of liberty that we are speaking about? This is necessary to check the arbitrary limits the power holders may put on the liberty. See, why we carve out a domain of liberty in the Constitution is all these rights, constitutional rights, are the limitations on the power of the state. On the power of the state. The state should not become a sort of power-drunk creature. It should not trample upon the liberty of individuals. See, we have created an institution against which the creator, the sovereign, becomes a common man, and he will not be in a position to match in the power equation the state power. So for that reason, constitutions will carve out a domain of liberty which is available to the individuals against the state. And if this liberty is to be deprived, it can be done only according to due process of law. That expression that we find in the American Constitution. And now what was started as procedure established by law at the guidance of Justice Frankfurter, when Sir B.N. Rao met Justice Frankfurter, he said, don't use this expression due process of law because it is like a double-edged sword, and sometimes it cuts both the sides, and we as a country have suffered under the wrong interpretation of due process of law. And you are a nascent democracy, you have come into existence now only, and you cannot afford doing the same experiments which we have done earlier. You go for an alternative phrase, and ultimately our constitution makers, they settle down with this expression, procedure established by law. But the Supreme Court over a period of time has interpreted this expression, procedure established by law, to mean due process of law, both substantive and procedure. So due process of law checks arbitrary limitation on liberty. Okay. Liberty means doing only permitted things, not prohibited things. What is permitted, what is prohibited is the prerogative of the state. What act to criminalize, what act not to criminalize is the prerogative of the state. So when state decides do's and don'ts and prescribes imprisonment, penalty, etc., it creates a crime. Crime, to put it in simple words, are the marks or the what you can say, temper with which the society denounces an act. So state denounces, condemns certain of the acts and prohibits them, and they become crimes. And what is in the interest of state, what is in the interest of the individual, what is in the interest of the society, the state will decide. There is what is known as state paternalism. State paternalism is an antinomy of individual autonomy. See, now we are heading more and more towards individual autonomy, and the state is withdrawing itself from the paternalistic behavior and conduct. What is paternalism? State stands in the position of parents to the citizens. As parents decide what is good and what is not good for their child, state also decides what is good and what is not good for its citizens. So you remember, attempt to commit suicide was a crime under the old Indian Penal Code. So that was paternalistic. State says, look, I am your father, I am your parent. You cannot decide what is good for you. Committing suicide is not good for you. As a parental figure, I have taken a decision that you should not commit suicide. Attempt to commit suicide, I am going to penalize, punish. This is paternalistic. State decides what is good and what is not good for the citizens, as parents decide for the citizens. But on the other side, you have got individuals, individual autonomy, personal liberty. They say, who are you to decide? We are in charge here. We take control of our lives. We know what is good for us, what is bad for us. They protest. They protest. So society is swinging between paternalism and autonomy, individual autonomy. Sometimes the pendulum will go towards paternalism. Sometimes the pendulum will go towards individual autonomy. And it all depends upon the phase through which the society will be passing through. See, this type of regulation of liberty is very, very important, because unrestrained liberty will result in conflicts. Pursuit of interest will result in conflicts. Unrestrained liberty, see, liberty is to be restricted in the interest of liberty itself. I recommend you, if you have not read, please read Harold Lasky, Grammar of Politics. Therein, very wonderful expressions. Liberty is limited by the equal liberty of others. I have liberty, and you also have equal liberty. Your equal liberty is the limitation on my liberty. My equal liberty is the limitation on your liberty. Wonderful book. See, these are the basic foundations type of books which we cannot afford missing. Harold Lasky, Grammar of Politics. Every public law student should read this book. So unrestrained liberty will result in conflict. And to avoid this conflict, liberty is to be subjected to state authority. Who has to regulate liberty? State has to regulate the liberty. That's why we spoke in terms of reasonable restrictions in the Constitution. Reasonable restrictions. Procedure that is just, fair, and reasonable. That means the authority of the state also is limited to regulate the liberty of the individuals. Look at that. Liberty is not unlimited, unrestrained. At the same time, power to regulate liberty is also not unlimited. It is also subject to limitations. And liberty itself is also subject to limitations. So what happens is, depending upon the time through which the society is passing through, the equations will change. For example, during laissez-faire era, laws were different. Even before that, see, if as students of law, you scan through the first 5 chapters of 10 outlines of criminal law, you will appreciate, or if you read Henry Maine, History of Thought and Crime, one of the chapters in Ancient Law by Henry Maine, you will appreciate that at the beginning, crime and civil wrong, crimes and torts were a sort of viscous mixtures. And depending upon the quantum of blameworthiness, the level of stigmatization, some of them went into become crimes, certain of the other things were classified as civil wrongs. And it has evolved over a period of time. In England, there used to be what is known as Husbands and Wives Act. The principle under that was, if the wife commits a theft in the presence of her husband, husband was liable for punishment. Because the belief was that wife is under the control of husband, but only husbands know that they are under the control of the wives. And the humorous side, okay? So, because of this equation, that the liberty should be limited and the authority to regulate liberty also should be limited, there evolved certain of the principles of criminal law. And where are these principles of criminal law? First, in creation of crimes. Second, the method prescribed for inquiry and trial. Third, the quality and mode of proof that is necessary to prove a person guilty. This is the code within which the game of enforcement of criminal law is played. What you call as penal code, procedure code, and the evidence law. And this was the product of laissez-faire era. And in the laissez-faire era, certain of the activities were criminalized. And in the very first chapter of Outlines of Criminal Law by Kenny, we stumble upon a very wonderful statement to the effect that crimes originate in the policy of the government of the moment. Crimes originate in the policy of the government of the moment. So what it means? It means the government which is in power today will decide what act to criminalize, what act not to criminalize. As we have seen, what is this? Unnatural sex is decriminalized. What is this? Then adultery is decriminalized. Attempt to commit suicide is decriminalized. Like that, certain of the activities which were prohibited hitherto got decriminalized. Certain of the activities which were not crimes will get criminalized. Creation of new crimes is the prerogative of the state. That is the implication when we say crimes originate in the policy of the government of the moment. What is the procedure that is adopted to prove that a person has committed an offense? We said due process of law is to be followed. What is due process? To put it in very simple words, what appears in 5th and 14th Amendment of the American Constitution. Procedure that is due to an individual before his life, liberty, property is affected in America. And here it is life and personal liberty. Procedure that is due. And procedure that is due, as it was stated in the cases subsequent to A.K. Gopalan, cannot be any procedure. It should be a just, fair, and reasonable procedure. That means the process to be followed by the criminal justice administration is highly formal in nature. Okay. If you want to find any person guilty of an offense, he will be found guilty only when facts are established according to fixed rules. Facts are established according to fixed rules. See, certain of the countries have the concept of excluded evidence. Excluded evidence. But we in India, we speak in terms of relevance of facts. We speak of relevance of facts, whereas they speak of excluded evidence. Unless it is excluded, everything on earth under the sky is relevant and that will enter the court proceedings. But here, when we speak of relevance, a crafty advocate, a knowledgeable advocate may be in a position to prove the relevance of a piece of evidence, then it will enter the court records. If the relevance is not proved, however important the evidence may be, it will stay out of court. This is the problem. So the facts will come according to the rules. Why it is like this? See, Justice Midhas, who laid down his office, say around 1 year back, 1.5 years back, he made a statement which went viral through the world. What was the statement? He said, both the parties know truth. It is the judge who is on trial, Justice Midhas. Both of them know truth. And justice, if he arrives at the same truth which is known to both the parties, then he is better off. Otherwise, judge will prove himself to be false because the parties know what is the truth. And same happens in administration of justice in villages who know who is who, what is what property belongs to whom. It is known to the whole village, but going by the rules of evidence, the document, this, that, something else may be proved. See, there is a joke. In the forest, one cow was running. Maybe some of you have stumbled upon this joke. Cow was running. Then elephant went and asked, why are you running so fast? You are sprinting. Why are you running like that? Then the cow said, forest officials are catching buffaloes. Hare, if they are catching buffaloes, why you are running? You are a cow. Then the cow said, you know I am a cow. I know I am a cow. But by the time I prove that I am a cow, my life will be over. Hearing that, elephant also started running. Because the same problem the elephant also will have to prove that it is an elephant and not a buffalo. So this is on humorous side. Long drawn procedures are there, and it is all because of certain of the basic principles. Why we have such elaborate procedure, lengthy procedure, formal procedure? It is because of two connected basic principles of administration of criminal justice. One, truth determination or determination of truth. If you check Justice Malimat Committee report, at the beginning only he mentions it very clearly. Quest for truth. Quest for truth is the sole motive of administration of justice. Administration of justice should arrive at truth. Finding truth is doing justice. Okay. So truth determination is very, very crucial. And the procedure should be so designed as to arrive at truth. This is one principle. And second, protection of individual rights and protection of innocent persons. See, when you set the criminal law in motion, it should be only for the purpose of punishing the guilty. And at the same time, individuals are to be protected. So these two basic principles, one, truth determination, another, protection of the individual rights or protection of the individuals. This resulted in two basic principles of criminal law on which till today the major criminal justice administration systems in the world were relying, especially Commonwealth countries. What are these two basic principles? Presumption of innocence. Presumption of innocence. And the sequel to it is let thousands go acquitted, not even a single innocent should be punished. Let n number of accused go acquitted, not even a single individual should be punished. Fair trial. In the anxiety of fair trial, procedural safeguards, even a real accused, a real criminal may find a way out, but that is the doctrine that these people, the criminal justice systems, adopted world over, presumption of innocence, and not taking a chance of punishing real culprits go scot-free. So they started working on these principles. Benjamin Franklin, one of the great jurists, he has made a statement. Those who are willing to give up little liberty for little security deserve neither security nor liberty. All those people who are ready to sacrifice little liberty for little security neither deserve liberty nor security. What is this? I will give you an example. In America, that Twin Tower blast happened. Planes were hijacked. They were flown into the buildings and the buildings collapsed. There was attack on Pentagon also. And after that, they enacted a law which is popularly known as Patriot Act. Under that law, a terrorist is declared to be the enemy of the nation. And the enemy of the nation deserves to be eliminated. A very strong law, which authorizes even ethnic profiling also. See, nation should survive. If to protect the nation, ethnic profiling is necessary, it should be allowed. If for protection of nation, if we have to sacrifice our liberty, we should sacrifice our liberty, depending upon the requirement. So that's why Benjamin Franklin says, those willing to give up little liberty for little security deserve neither security nor liberty. You look at what is happening in Bangladesh. A democratically elected president has run away from the country. The prime minister, sorry. So what is the law and order situation there? Why the country is boiling like that? Now, today I was reading in the newspapers that people are finding it difficult to guard their own property against the people who come there to loot the property. The whole country is on the rampage because maybe that system did not regulate. That system did not regulate the liberty. Liberty is very, very difficult. See, state should regulate liberty. At the same time, people should have liberty for their individual dignity and expression. Liberty, we have to sacrifice. In the interest of liberty again, As long as this constitution is there, as long as this constitution is there, the domain of liberty is there. I can speak and express. I can do whatever I want, as long as the constitution is there. Once the constitution is not there, my domain of liberty will be forfeited. Please read Pauline Ariman. Before memory fades or God Save the Honorable Supreme Court. In one of these books, probably it is before memory fades, wherein there is a chapter on minorities. Minorities, he says, the majority in a democracy should understand that it is a majority with small m. It is not a majority with capital M, it is a majority with small m. And the hallmark of democracy is protection of minority, going by any standards. Having said that, he says, at the same time, minority also should understand that it is a minority with small m again. And it should know how to go with the majority. Minority can assert itself because it has a constitutionally protected right. And as a minority, you cannot do anything that can affect that constitution, because if that constitution is not there, you are not a minority and you are away. You will lose all your privileges as a minority. Behave. So what a wonderful analysis. What a wonderful analysis. My dear friends, you have to, everyone, including me, all of us are perennial students of law. And one of my professors was always repeating, law is a jealous mistress. And she needs your constant attention, affection, and love. And if it is not forthcoming, she will go somewhere else. If you want to keep this law with you, you should constantly say, go after that, follow, understand, appreciate. All these things should happen. So please read these books. Okay, as long as the constitution is there, I am a minority, I have the constitutional rights. So constitution should serve me. Anything separatist, anything subversive, anything that can affect unity and integrity of the nation should be dealt with an iron fist. There is no compromise, no alternative. And every one of us should be votaries for this stringent handling of the situation. There is a very famous quote from the Chinese authors. A single criminal law enforced with unerring accuracy is worth all the words of all the sages. That's what Chinese Themists used to say. See, this is the requirement. Criminal law should be strong. There is another saying, a subtle law is seldom respected. A stringent law is seldom enforced. A subtle law is seldom respected. A stringent law is seldom enforced. If the law is very subtle, very feeble, very weak, nobody will respect it. Riding without helmets, smoking in public places, over speeding, all these things people very generously violate because they know these things will be there, they will not enforce that. Subtle laws are not respected by me. But when there is a very, very strong legislation, stringent laws, and before a case is booked under a stringent law, even the enforcement authorities also will think twice, because they know the draconian nature of law. And once that law is put into action, the boy or the girl may go beyond the walls, into the prison, into detention, wherein he or she will come in contact with all dreaded criminals. And beyond wall, we say there is university of crimes. Therein you have got all levels of people trained in crimes, right from certificate level to postgraduate, postdoctoral level. So if this youngster, first time offender, if he is sent into custody, maybe he will come in contact with certain of the people who will give him information and mislead him, and maybe he will become a burden in the society, unwanted element in the society. That is the problem. We should be ready to sacrifice our liberty for our security. And if we are not ready to sacrifice our liberty, the criminal law, stringent criminal laws, when the time demands, we should accept. There is no way out. That's how we have very, very stringent criminal laws in the contemporary society. And at the same time, at the end of laissez-faire, when there was exploitation, there was misery, penury of the have-nots by the haves. The concept of welfare state started developing. And the old doctrines did not respond to the new situations. New types of crimes came into existence. The old doctrines did not yield results. So in that new situation, there was a change in the laws which were designed to regulate certain of the activities and to prevent crimes, to punish the guilty. So here, at the end of, say, industrial revolution, when we started speaking in terms of a welfare constitution, the new criminal jurisprudence develops. For your information, Dr. Bhuvaneshwari was a student of the University College of Law, and there are certain of the others also who know about this. We ran an honors course in the University College of Law. And those days, we started honors course in 97, 98. Those days, when only National Law School was offering honors program, we said we also will offer honors program, and we offered it on a semester basis, not on a trimester basis. Loaded semesters. And because that was the only institution which was operating this program, we had included certain of the additional subjects. I had included one subject under the banner, social and economic crimes. This was coming after the first criminal law, Indian Penal Code. Second criminal law was social and economic offenses. CRPC and evidence we studied separately. What was the content of this? Why I included this in the syllabus? See, for the success of all our graduates, there are so many contributing factors. First, that class of students. Students as a group. Students as a group belonging to that institution. Students as a group belonging to that class. So much of solidarity, I tell you, wonderful. Exchange of information, fellowship, everything. That's one thing. And second, collaboration between the teachers for the good of the students. Excellent coordination amongst the teachers, between teachers and students. And third, discipline. If these three things are there, students can undertake any tough subject, any number of courses, and excel very well in all the subjects, in all the courses. And this one, see, when I framed this syllabus, some people scolded, what are you doing? You will not believe, and you have to believe. There were 35 statutes prescribed for this one subject of 100 marks. Right from atrocities law, PCR law, Telegraph Act, Post Office Act, and Telegraph Wires Act, Railway Property Unlawful Possession Act, NDPS, illicit traffic in NDPS, TADA, FOTA, Coffee Posa, Preventive Detention Act. I tell you, 35 legislations prescribed for one subject, and the object of the course was to study and understand how the mode of proof and quality of proof changes depending upon the gravity of crime, depending upon the nature of the crime, how this regime of quality of proof, mode of proof changes. This was the agenda that we set as a part of that course, and that's how some of our students, and as a teacher, I also had to learn how the dimensions of criminal law change, paradigms of criminal law change depending upon the gravity of crime, depending upon the time frame through which the society passes through. And through these legislations, we were in a position to glean away certain of the principles. What are these new elements, new components of criminal jurisprudence that came into existence at the end of laissez-faire and the emergence of the welfare state? Strict and absolute liability started entering criminal laws. Vicarious criminal liability, corporate criminal liability, shifting the burden of proof to the accused, presumption of guilt. It is for the accused to prove that he is innocent. Pressing into service deterrent punishments, prescribing mandatory minimum punishments, prescribing high crimes. See, it is so unfortunate. As students of law, we have to read, reread things. I have sat in several interviews, and sometimes I ask very silly questions. And sometimes one of the respondents, he came to me and said, "Sir, you ask very funny questions." He felt these questions are very funny questions because he gave only wrong answers. Okay. For example, whether mens rea is a necessity to constitute a crime in India, the answer is no. Mens rea is not a necessary element unless it is specifically required by the section. But a lot of students walk out of the portals of the college with the presumption that mens rea also should be there. Actus reus. What is actus reus? I tell you, I am tired of this. Once I had put this question in the PhD entrance examination of Bangalore University. I gave an example. A person shoots and kills. What is the actus reus in this? ABC answers. The right answer which I had given, so many people contested that the right key answer is wrong. For them, shooting was actus reus. But actually, death is the actus reus, not shooting. This commotion and confusion arises because we have stopped reading quality literature. We have stopped reading prescribed materials, especially those who have longer service. If you are to retire in 1 or 2 years, okay, anyway, you have lived this service and complete the service. Another 2 years, and as that last man completes the race, last loop also he runs, complete it, fade away. But if you have service, my dear friends, I tell you, you have to have total control on the subject that you are teaching. Keep on learning, keep on learning. If you have not read those basic prescribed standard books, go back and read, because you have service, and throughout you will be in a position to serve your students in a better manner, and you will be so happy personally. At least for your own happiness, you have to do this. Don't avoid. And if there is a teacher of criminal law here, I tell you, you have to read Glanville Williams, Criminal Law. Joel Feinberg, 2 volumes. Harm to self, harm to others. Kenny's Outlines, you have to read. Smith and Wagon, you have to read. Maybe you will take, say, a reference from certain of the other teachers also, and you have to excel very well. See, when we are thorough with this, we can speak in terms of the good or bad of the policy. We can speak in terms of policy suggestions. We can speak in terms of policy reforms. Unless I know these things, I cannot participate in any debate. For that reason, we should keep on reading. Strict liability, absolute liability, vicarious liability, burden of proof being shifted, presumption of guilt, deterrent punishment, mandatory minimum punishment, high fines, confiscation of goods, denial of benefit of probation, summary trials, making the offences cognizable, non-bailable, constituting special courts, all these things entered criminal law through different legislations. High fines. See, if that Karodpati, if that entertainer, I refuse to call these film fellows as heroes or heroines. They are not heroes. They are entertainers. Okay, you have to understand this. Don't make heroes out of the actors. They are only entertainers. If that entertainer who amasses wealth to the tune of crores, if he is also put to same 500 rupees penalty when he violates a traffic rule, in our minds, 500 rupees is nothing for him. It will not have any effect also. So for that reason, put heavy fines. If that Karodpati violates a traffic rule, let it be in terms of crores. What the common man, what a daily wage earner, if daily wage earner is put to a penalty of 500 rupees, this industrialist, you put to a penalty of, say, 5 crores, 10 crores, then only he will feel the pinch of it. As students of administrative law, we used to study our teacher, Professor Devidas. He was always saying, if you pinch a person at his purse, he will feel it at his heart. So there is a direct link between purse and heart. Okay. So if you pinch the purse, he will feel it at heart. And prohibitive penalty. See, Vijnaneshwara, if you read Mitakshara, during that time only he had prescribed. When you are sentencing a person, when you are imposing penalty, he has prescribed what are the criteria that are to be looked into for the purpose of quantifying penalty. And one of the criteria was ability to pay. Ability to pay is a factor to be considered. He is a poor man, he is not capable of paying, impose less penalty. He is a rich man who is in a position to pay hefty penalty, impose hefty penalty. See, then only Vijnaneshwara prescribed like that. These things have entered the criminal law world now, wherein high penalties are there. Confiscation of goods is there. Denial of benefit of promotion, all these things constituting special courts for the speedy and expeditious disposal of the cases which affect the society in a bigger way, and when the dreaded criminals are involved. So all these new principles have come into existence and they have entered the criminal jurisprudence through various statutes. Okay. And is there a conflict between the due process of law and these principles of new criminal jurisprudence? For this, the answer is, it all depends upon the time frame through which the society is passing through. It is a pendulum swings. Sometimes it will go towards the state, sometimes it will go towards the individual. What was not in conformity with due process sometimes will come to be in conformity with the due process. So right now, the review of that decision which upheld the PMLA to be constitutionally valid is pending before the Supreme Court. So it has gone before a larger bench as to whether this earlier judgment which said PMLA is constitutionally valid. See, PMLA is dubbed to be a very draconian legislation, and that is held to be constitutionally valid. See, the case is Vijay Mandal Chaudhary versus Union of India. So in Vijay Mandal Chaudhary versus Union of India, Prevention of Money Laundering Act is held to be constitutionally valid. Now that is referred to a higher bench, a larger bench, and again they are reviewing. And subsequently, you have heard through two decisions, the power available to the investigation machinery under PMLA Act is watered down. They have given guidelines to tame the power that is available at the hands of the state agencies. So that's how the processes, the paradigms are shifting. There is a great message in the words of wisdom expressed by Jeremy Bentham, another great writer. Jeremy Bentham, he says, every precaution which is not absolutely necessary for the protection of innocence affords a dangerous lurking place to crime. I repeat, every precaution which is not absolutely necessary for the protection of innocence affords a dangerous lurking place to crime. What maxims of procedure can be more dangerous than those which put justice in opposition to itself and which establish a kind of incompatibility between its duties? See, what a wonderful statement. All procedural protection that is absolutely not necessary for protection of the individual, innocent, provides a lurking danger, a loophole for the criminal to escape. That's why people are so happy committing crimes and getting away with that. The rate of conviction that you see in the... But the purpose of criminal law is not to punish at any cost. The purpose of criminal law should be to punish the guilty. It should be to punish the guilty. I picked this up from one of the books of Fali Nariman himself, probably God Save the Honorable Supreme Court. In this book, God Save the Honorable Supreme Court, he reproduces the motto that is written on the Rotunda of Justice Department in the United States. See, in that wall, it is carved in the Attorney General's office. And what is the statement? The United States wins its case whenever justice is done to one of its citizens in its courts. The United States wins its case whenever justice is done to one of its citizens in the courts. So what is the pride? The motto of the department is not conviction at any cost. The motto is whenever justice is done to an individual, to a citizen, United States celebrates its victory. Innocent is to be protected, there is no confusion. Guilty are to be punished. Again, there is no confusion. And for this purpose, there should be a discrete combination of different principles for the purpose of tackling the crimes that come into existence in the society. By now, as the new criminal laws, the Bharatiya Nyaya Shastra, Bharatiya Nagarika Suraksha Shastra, Bharatiya Saksha Adhiniyam, these three things have come into force. And of all of us as law students have tried to acquaint ourselves with the new provisions. Right now we are grappling with the numbers. We will acquaint after a while, but at least with the principles we have acquainted by now. See, for the first time, you will see so many crimes being prescribed a deterrent punishment, mandatory minimum punishment. There are so many crimes for which mandatory minimum punishment is provided under the new laws. See, mandatory minimum punishments, there is a danger in that. What are the mandatory minimum punishments? When mandatory minimum punishment is prescribed, once convicted, the judge has no alternative but to give him that minimum punishment. Not less than, not less than, not less than. Generally, in criminal law, the sanction will be, you shall be subject to an imprisonment for a period which may extend to. Higher is prescribed, minimum is not prescribed. Depending upon the outer limit, the judge is allowed discretion to quantify the sentence. And whenever minimum sentence is prescribed, judge has no discretion but to award that minimum punishment. And that is a sort of legislative judgment. Legislature has decided what shall be the minimum, irrespective of the either mitigating or extenuating circumstances. Okay, judge loses discretion. When the judge loses discretion, for him the option will be when an youngster, when a first-time offender, when a well-educated individual who has all the possibilities of reformation, who regrets having committed crime. In such a situation, for him the option will be to acquit, find some reason, give benefit of doubt, acquit that person, because if you convict, minimum punishment, he has to go behind the wall. And once he serves that sentence, he will become an ex-convict.
ಹೌದಾ, ನಾನೇನೋ ಕೇಳೋಣ ಅಂತ ಅಷ್ಟೇ.
Please
Okay.
continue, sir.
No, that's fine. I also wanted to listen to what the person said. See, criminal law, there should be some interludes in between. And humor is part of life. That is very much required. So, what happens is the only alternative will be, see, under illicit traffic in narcotic drugs and psychotropic substances, and under NDPS Act, minimum punishment is there. And who are these people? These are the college-going boys and girls who have picked up that stuff and have done something and they are apprehended. And now minimum punishment, if you convict him, the fellow will go to jail. The whole life will be ruined. Out of curiosity, out of seduction, out of veritable fashion, X, Y, Z, this fellow resorted to that consumption of the drug. And the whole world will be upside down for him for this. So once convicted, he has to go to jail. So in such situation, a judge is not willing to convict him because once convicted, he has to go for a minimum period. So when we prescribe mandatory minimum punishment, we have to pick and choose the appropriate crimes because only such dreaded crimes should carry mandatory minimum punishments and not otherwise. Okay, then you have for the first time very clearly defined imprisonment for life for certain of the sections in the Act, in the Bharatiya Nyaya Samhita. They have very clearly and categorically written till the end of natural life. It is not 14 years probation benefit, XYZ. No. Life imprisonment means very clearly they have written till the end of natural life. See what is the extent to which he is losing liberty. It is all in order to have that deterrence. We have that deterrent effect on the potential offenders. Look, if you do this, you will go beyond the wall for the life. Till the end of your life, only your dead body will come out. Decide as to whether you can afford committing this offense or not. So this is the another thing. Till the end of life, that's what. And for the first time, they have prescribed community service as a form of punishment. And unfortunately, community service is not defined in the Bharatiya Nyaya Samhita. It is defined in the Nagarika Suriksha Samhita. Under one of the clauses, when judge is given power to impose punishments, it is stated that he may impose. And they have listed the offences for which community service may be imposed as a punishment. This is only again in order to press into service the reformative dimensions of the criminal justice system. Wherever there is a possibility for petty offences, they have listed the offences for which community service will be available. What is community service? It is a compulsory work extracted as decided by the judge, which the person who is put to that sentence has to perform. It is a compulsory work extracted for which there is no honorarium, no payment. Community service. This is one of the very beautiful provisions that has come into the system that is very, very useful. But the definition is not crisp or such other similar things it is mentioned. And maybe we have to wait for the guidelines by the Supreme Court and higher courts as to what all can be classified as community service. If a doctor commits an offense and if he is put to community service, they may say you have to go to Vivekananda College every month and health checkup free for the faculty members, for the students, for the non-teaching employees. So that is the punishment for him. He is a doctor. Don't put him in the prison and give Sarkari Khana. Send him to the society. And there is a person who is convicted and who does not know anything. Okay, you go and sweep this college, sweep this government office free. Morning, you have to take the letter, go to that office, clean, take attendance, and go back to prison and stay there. These types of services, instead of keeping people idle in the system and feed them, use their services for constructive purposes. This is the idea behind community service, and wherever the offense is very petty and wherever there is a possibility of reformation, use that. But it is my personal opinion that they should have made this expiative punishment. They should have made this expiative. See, when we are filling the columns, that column comes, were you convicted? If the punishment is expiative punishment, in that column, a person can write no. Because the punishment is expiative, once you serve that punishment, you are clean, as good as a person who has not committed any offense at all. So such beautiful dimension is there for the expiative punishment. And here it is not expiative, and we have to wait and see whether there can be further developments in due course. And when the country as a whole has taken up this exercise of overhauling the criminal justice system, I feel they should have gone further. When Justice Malimat Committee was working and ultimately submitted its report, there was a parallel criminal justice committee that was going on in United Kingdom. And one Lord Robin Holt has made a statement. When UK is tinkering with the peripheries of criminal law, India is taking leaping strides in reformation of criminal law. See, India is not an ordinary country. The world looks at us because we are the leaders in contributing ideas and the principles. We should have gone further ahead, and there was a lot of scope for improvement. I recommend to you to read this book, Howard Zar, Z-H-A-R, Howard Zar, a small book on restorative justice. A small book on restorative justice. I tell you, as students of law, we have to read. There is no alternative. We have to read. If some of you have bothered to look into the concurring judgment of Justice Kaul in what is this? Article 370 judgment. Okay, abrogation of Article 370 was challenged and the judgment of the Supreme Court came. There is a concurring judgment of Justice Kaul in that. And therein, Honorable Justice Kaul recommends there should be impartial truth and reconciliation committees constituted. So when I stumbled upon this expression, I feel elated. I felt so happy. Okay, there is a judge here who speaks of TRCs, Truth and Reconciliation Committees. So I felt elated. Why I feel elated? Because I had the opportunity of reading something about Truth and Reconciliation Committee in one of the books of Stephen Covey. Stephen Covey, that famous author of the 7 Habits of Highly Successful People. The next book, Living 7 Habits. The 8th habit, Living 8th habit. Third alternative. Third alternative is a wonderful book, and I recommend every ADR teacher should read that chapter on third alternative at law in this book of Stephen Covey. There is a third alternative. And in this chapter, I stumbled upon Truth and Reconciliation Committees. And there is reference to Truth and Reconciliation Committees in Howard Zarf's Restorative Justice also. My dear friends, I tell you, 2 or 3 months back, I read in the newspaper that a girl who was a victim of rape was thrown out of a school in Gujarat. You can Google, you'll get the details. She is a victim of rape. And a victim of rape is sent out from the school. So we do not want a rape victim in our school. What is the mistake this child has committed? Whatever mistake that is committed, blameworthy, condemnable, that is done by that man who has raped this girl. This is a victim. This is a victim. Because the offense is rape, and you feel the girl is stigmatized, and you feel a rape victim should not be in your school, you throw her out. The neighborhood will look down upon this girl who is raped. The family members also may not feel so good about this child who is a victim of rape. We have to understand all condemnation that we have, utmost language, vehemence, condemn that culprit, not the child. Why we are like this? Why we are not in a position? Why a school is not in a position to appreciate that this girl is a victim? Because the teachers there, the management there do not know how it is to be a victim. They are not counseled properly to receive a victim of crime. Okay? When huge offenses, genocides, disappearance cases are happening in the apartheid in Africa, that happened. TRCs were constituted at the end of aftermath in Africa. Brother has disappeared, father has disappeared. I don't know whether the person is alive or dead, but I am living. Now the country has a democratic order, but I do not know what happened to my father or brother. My only request is, give me facts, give me truth. Give me truth. First, whether my father is alive or dead. If he is alive, where he is. If he is dead, please let me know whether it was a peaceful death or a violent death, how he was killed, whether he was buried, whether it is a marked grave or whether it is a mass burial. Give me the facts, and I do not have any vengeance against anybody. I have no complaint against anybody. I do not want anything. Give me facts because my life has to go on. I will reckon how long I have to wait for my brother, how long I have to wait for my father. If you know that my father is no more, tell me. If you know that my father is there somewhere, say detained in some prison, and he will be released after 10 years, okay, I know that my father is alive, and after 10 years, I have a chance of meeting my father when he is released. Give me truth. And with that truth, I want to live. This is TRC, Truth and Reconciliation Committee. Facts are facts. And we have to reconcile with, this is called restorative justice. See, as students of law, you should know that there is one more dimension of justice, that is restorative justice. Restorative justice is not just about punishing the guilty. It is about expressing compassion, making the life more acceptable, worthy for the victims of a crime. So when we spend so much of attention to prosecute and punish a criminal, as a system, we should bother equally about this victim who has faced. See, no victim wantedly, see, some calamity has befallen upon this victim, and this victim, this victim is to be protected. See, different dimensions. When the country goes on for a overall like this, as researchers, as thinkers in the field of law, we should be in a position to put these ideas by writing letters to the Law Commission, by writing letters whenever the discussion is going on. These bills were open for consultation, no? As teachers, again, whenever there is a opportunity, we have to express our opinion, we have to give our suggestions to the system when suggestions are innovated. And separatist activities, I told you. See, earlier we used to have specific laws, TADA, POTA, NASA, what is it, NSA, Preventive Detention Act, COCA, Karnataka Prevention of Organized Crimes Act, Maharashtra Prevention of Organized Crimes Act. See, these special legislation were there, which were in operation for a limited period of time. And even now we have got Unlawful Assemblies Prevention Act, which is supposed to be, which is represented as a sort of draconian law. Okay. When all these laws are there, whether again we should have stringent provisions in the Indian Penal Code. By now we have the stringent provisions in the Indian Penal Code. It is there. The offense of sedition is taken. Okay, please read A.G. Noorani, the historic trials. Okay, a new edition has come. I have read the old edition, and 2 chapters of the old edition are taken away, 2 new chapters are added. What a wonderful one. Therein you have got trial of Mahatma Gandhi, trial of Balagangadhar Tilak, trial of Adi Shankaracharya, trial of Muhammad Ali and Shaukat Ali. It's such a wonderful book. And I had another book which I have given to one of my elderly friends, and he said, I will keep this book. I will not return this book to you because I want to have this book. I said, please keep that book with you, sir, whenever necessary. I will borrow it from you. Mind-blowing trials of the world. Mind-blowing trials of the world. That is a mind-blowing series. Mind-blowing organized criminals, mind-blowing terrorists, mind-blowing cheaters, all mind-blowing series. This is mind-blowing trials. Trial of Joan of Arc. Trial of Socrates. Trial of Mahatma Gandhi. Trial of the assassins of Kennedy. I tell you, trial of Socrates. All, see, we have to read as teachers of criminal law, we have to read these books, wonderful books. When you read the trial of Mahatma Gandhi, the judge, Bloomberg, should be his name, utmost respect was shown to an accused in a trial, because they were all knowing that they are involved in making history. They were knowing that all these things are going to be recorded for posterity. That's why they were all very careful. Mahatma Gandhiji pleaded guilty for sedition. He did not contest. Had he contested, we don't know what the judgment would have been. But he said, I plead guilty. What you consider to be sedition, I consider as the service to my motherland. I am a patriot. If your law says being a patriot is a crime, I am so happy that I have committed this crime. Please read these books. You will understand how great these people were. He pleaded guilty. Now, judge has no alternative but to punish him. You have to read that judgment. I tell you, it is so beautiful. He refers to the trial of Tilak. He says, Tilak was a greatest patriot going by any standard of your country. And when Tilak was prosecuted for the same offense, he was also charged with the same offense. And he was sentenced to a term of imprisonment. As a judge, I will be failing in my duty if I am not going to prescribe the same sentence which was prescribed, which was imposed on Balagangadhar Tilak. So saying so, he awarded the same punishment to Mahatma Gandhi, what was awarded to Balagangadhar Tilak, and he saved himself. So this provision under which all our freedom fighters were prosecuted, see, under the new system in an independent India, this provision of sedition under which our leaders were prosecuted should not be there on the statute book. They said, we will remove this. There was some doubt expressed about the validity of sedition law after independence by the Supreme Court also, and that is taken out of statute book. A new provision which is condemning secessionist activities is brought in with the stringent punishment. So like this, there is a discrete combination of a reformative school of thought and prohibitive preventive school of thought, which is pressed into service under the new criminal justice system. These are the changed dimensions, paradigms, shifted paradigms of criminal justice system obtaining under the new criminal law regime. So with that, I conclude. And if there are questions, I can take some questions. There are 10 messages in this box.
Thank you, sir.
Yes, ma'am.
Thank you, sir, for delivering an enlightening and thought-provoking session on changing paradigm of the criminal jurisprudence. We deeply appreciate the vast knowledge and expertise you shared with us, significantly enhancing our understanding of this crucial area of law. With your permission, can we now move on to address the queries that have been posted by our participants in the chat
Yes,
box?
ma'am. Yes, ma'am.
Yeah. Dr. Pragna S. Patil asks, sir, about the levy of fine, will it be suitable to fix fine based on their annual income? For example, 0.5% of his annual or monthly income rather than a fixed rupees 500.
Yeah, that's what I was speaking about when I made reference to the penalties. What is the criteria? See, we have to take into consideration the other way around also. There are different theories and different, what you can say. See, when we, there was a recommendation by a committee that defamation should not be a crime because that is a civil wrong. And you have heard of this case, contempt of court case against Prashant Bhushan, wherein he was imposed a penalty of 1 rupee. See, whether it is 1 rupee or 1,000 rupees, penalty is a penalty, it is punishment. The guilt is blameworthy.
Okay, sir. Thank you. Thank you.
He is a convict.
Okay.
Whether it should be commensurate with his ability to pay I am of the opinion it should be. It
Okay,
should
sir.
there is some rationality. See, what is punishment for a poor man in terms of monetary terms? See, when it is imprisonment, if you sentence him for 1 month imprisonment, irrespective of his affluence, he will be suffering the same. But when it is penalty, this rich man has no brunt, but the poor man feels.
Yes, sir.
I said, ability to pay is one of the things to be considered. Good, Pragya.
Yes, sir. Srimati Kalpana ma'am says, good evening, sir. It's been a pleasure to listen to your well-structured discourse. Given the hostility to the newly enacted criminal laws, do you think they will yield a noticeable positive impact on our society as a meaningful step?
Okay, Madam Kalpana, see, we have now started. I was fortunately part of that committee constituted by Karnataka government to study these criminal laws and submit a report which went to the Union Home Minister. Some of the recommendations are incorporated, some of them are not incorporated. How it yields good result? I will take you to the statements of all these great people, Dr. Baba Saheb Ambedkar, the President of the Constituent Assembly, Babu Rajendra Prasad, and all of them, they said, see, it is not the law. Whatever the Constitution may or may not provide, the welfare of the country depends upon the persons who administer it. This is the criminal law regime. How we enforce this criminal law regime? I tell you, if you want to know what is the level of civilization of a country, just run down your finger through their criminal law, criminal justice system. You will understand what is the civilization level of that country. There are so many statutes to protect women in that country. That means the country is not safe for women. There are people who commit this crime. That's why there are statutes. If there are laws to prevent violence against elderly people, we have to understand that the youngsters have become so indifferent towards the welfare of elders. See, criminal law is a curse, and we cannot afford without criminal laws. And these new criminal laws, we have to wait and see, hit and run cases. How we are going to interpret those loose words, open-ended words that are there, like economic offenses, contract killing, land grabbing, petty organized crime. See, veritable things have come into existence. We have to wait and watch how the higher courts will issue guidelines to structurize the exercise of power by the criminal justice administration system. Hope there will be good interpretations. There will be no provision for abuse of law. I am an optimist. I am optimist compulsorily. I have no option. That's why I am an optimist. Madam Kalpan.
Okay, sir. Thank you, sir. For any other queries, participants are welcome to unmute your mic and ask the speaker. Any other queries from participants?
Good evening, sir.
Good evening.
Good evening.
This is Dr. M. Jayashree from Mysore University School of Law.
Okay.
Sir, I want some clarifications about white collar crimes, sir. Sir, some traditional crimes we are having many types of justices, but white collar crimes, whatever the suggestions that the people do in the administrative block. So I want some clarifications.
See, madam, these white collar crimes, see, when professional people are involved in committing crimes, they are plus white collar crimes are again crimes, normal crimes. Committed by qualified people, it becomes white collar. Committed by less qualified people, it becomes blue collar. See, whether a doctor is committing that, or see, in that Porsche case, Porsche car accident case, doctors were booked. Okay. What is that? Misrepresentation, falsification of documents. They are the same crimes, whether committed by doctors, but we study under the white collar crime. That is that goes under a different heading. But what is pitiable is these people who are bound by professional ethics, these people who are well qualified, they are also committing crimes. That is very blameworthy. Why people commit crimes? What is the magnitude? Really, it is very alarming. That's why, rightly, the organized crime has come into this new system. And white collar crimes, some of them will come straight into organized crimes because there is a syndicate which is operating these things. But really, it is very, very disturbing. Really, it is disturbing that these things are happening in a civilized system, but there is no alternative but to have stringent laws. Doctors committing it, lawyers committing it, judges committing it, professors committing it. See, all these things are white collar crimes. But unfortunate, these things are there. And see, bank scams, hoarding of money, laundering, then majority of them will go under special laws. But that is a fact that is there, and we cannot avoid that. And it is not so nice to, I tell you, please read this Subrato Bakchi's, the professional book, how the learned people become criminals, because they become criminals because they are not professional. If they understand the meaning of professionalism, they will not run into that problem. And quite a few white collar crimes have come into this normal criminal law under different guise, and they are going to have severe repercussions. Yes, ma'am.
Thank you, sir.
Okay,
Any other?
thank you.
Thank you, sir. Any other queries from participants? Okay. Thank you, sir, for patiently and thoroughly addressing all the questions from our participants. Thank you very much. To conclude this session, I now invite Dr. Bhuvaneshwari S.K., Assistant Professor, to propose the vote of thanks.
Respected sir, Professor Dr. C.S. Patil sir, Chairman, Governing Council, Sri M.R. Lakshmi Manohar sir, Principal sir, and dear participants, friends. I deem it my privilege to propose the vote of thanks for today's session, which has been held by a celebrated teacher and my guru, Professor Dr. C.S. Patil sir, Director, Kilpar. At the outset, I, on behalf of our institution, express heartfelt gratitude to you for educating us on the key changes brought about by the newly introduced criminal laws based on the present Indian needs and aspirations. Thank you very much, sir, for your valuable time and
Gerard.
insightful session. We have
Thank you.
highly benefited by your discourse, and we look forward to more such interaction in future too. It's my pleasure to thank our management, Janta Education Society, and Sri M.R. Lakshmi Manohar sir, who stand firmly with us in all our academic endeavors. Thank you very much, sir. It's heartening to thank respected principal in his absentia, Professor Dr. K.B. Kempegowda sir, for being the guiding spirit behind this FDP. I feel it happy to thank all the dear participant friends for your active involvement in the program. Thank you one and all. And even I thank Srimati Nirmala P. Hegde for hosting this session. Thank you so much, sir. Thank
Thank you.
all
I
the
take it.
participants for joining us. Thank you so much.
Thank
All
you,
the best.
Bhuvaneshwari, ma'am.
Thank you.
Thank you. Yeah, I kindly request all the participants to fill out the feedback form, which we are going to post now. Sorry for the delay. We will post now the feedback form link. And we look forward to your participation in tomorrow's session on substantial changes introduced by the Bharatiya Nagarika Suraksha Sanhita 2023, which will be conducted by Dr. M.K. Matholi, Associate Professor, Department of Collegiate Education, Government Law College, Hole Narsipura. Kindly fill the feedback form. Which way, Bhuvaneshwari ma'am? Did you post?
No. I have not posted.
Okay, we will share the link of the
Okay.
feedback form. Please wait. Thank you. Thank you, sir. Thank you all once again for your active participation. We will share the feedback form link now.
Madam, you only share.
Hmm?
ನೀವೇ ಮಾಡಿ.
Okay.
ನನ್ನ ಲಾಗಿನ್ ಆಗಿಲ್ಲ ಫೋನಿಂದ. Participants, please fill the feedback form. It is already shared in the group. Sorry, in the chat box.